Welcome back to another video, and in this video we're going to be looking at part 3 of Certainty of Intention. And so far we've looked at some particular words which may or may not amount to an intention to create a trust, and we've also looked at section 22 of the Administration of Justice Act 1982. And in this video we're going to be looking at something called inferred intention. And the court may infer intention to create an express trust from the words or actions of the legal owner or settlor. And there really aren't many cases in which this has happened. But we've got a case here, Twinsectra and Yardley, and Lord Millett in this case said that a settlor must, of course, possess the necessary intention to create a trust, but his subjective intentions are irrelevant. If he enters into arrangements which have the effect of creating a trust, it is not necessary that he should appreciate that they do so. It is sufficient that he intends to enter into them. So he says that intention is objective and not subjective. Okay, intention is about whether the reasonable person believes the settlor intended to create an express trust. So the settlor doesn't need to know they are creating a trust, nor even know that a trust even exists. If their actions or words have the effect of creating a trust, the court will infer intention from those words or actions. We also have the case of Paul and Constance. Now, this is probably the best example of the court inferring intention. So, the best example of the court inferring intention is found in this particular case. Now, in this case, Mr. Constance left his wife to live with his mistress, Mrs. Poole, and Constance received a court award of £950 for an injury suffered at work. Subsequently to which Constance and Paul decided to set up a joint bank account. After visiting the bank, they were advised that the account should be set up in the name of Constance alone because the couple were not married. Therefore, Constance was the common law owner of the account. The £950 lump sum was paid into the account and formed the bulk of the money held in it. The couple also added joint bingo winnings into the account and used some of the money to pay for a joint holiday. Importantly, evidence was also adduced at trial that Constance had said to Paul, "This money is as much yours as mine." And then Constance died. His wife sought to claim that the bank account belonged entirely to her deceased husband and that it therefore passed to her as his widow under the intestacy rules. Paul argued that the money was held on trust by Constance as legal owner of the bank account for both Constance and Paul as beneficiaries. Therefore, Paul argued, the bank account should pass to her as sole surviving beneficiary. The litigation was therefore the staple of soap operas, the spurned wife fighting against the new lover. Okay, the court held that Constance had declared a trust over the money in the bank account. The reasoning was that the words "the money is as much yours as mine" manifested sufficient intention that Constance would hold the property on trust for them both. Furthermore, that the couple had treated the money in the account as joint money was taken to evidence the intention to create a trust. The court held that the trust was an express trust, even though, in the words of the court, Constance was a man of, quote, unsophisticated character, who did not know he was creating a trust. In other words, you can create a trust without even knowing there is a legal concept of trust. Instead, the court will consider your conduct and take your real intention in deciding whether or not you can be taken to have intended the creation of something which the court would interpret as being a trust. Okay, so that's Paul and Constance. We've also got a case of Shah and Shah, and in this case, the words that were stated were, "This letter is to confirm that out of my shareholding of current 12,500 in the above company, I am, as from today, holding 4,000 shares in the above company for you," and that was held to create a trust. So although the word trust is not used, it was held this did create a trust, okay? And this is fairly unambiguous. The other key case we probably need to look at is a case called Cayford from 1975. And the company facing insolvency had put customers' payments for mail order items into a separate account, and the court held that there was an intention to form an express trust. So this is another case where the court is uncovering an express trust than imposing one of our implied trusts, rather than imposing a constructive trust. Okay, so in this case, a mail order company, and that's just a company which lists their products for sale in a catalogue or website for consumers to buy via telephone, mail check with order form, or internet order. Okay, so a mail order company used used to receive money from customers buying items from their catalogues before those items were sent to the customers. The customers therefore bore the risk that they had paid their money, but they may not receive the item for which they had paid. The mail order company realised that it was in danger of insolvency and therefore segregated all of its prepayments into a distinct bank account. Money was moved from that bank account only once the item had been sent to the customer. When the company did go into insolvency, the issue arose whether the money belonged to the company and therefore would be distributed among the company's creditors, or whether it was held on trust for the customers and therefore could be returned to them. The court held that the company's intention was to create a trust over the prepayments, which had been manifested by transferring those prepayments into a separate bank account so as to shield them from the insolvency. This case illustrates the important role which the trust plays in protecting the beneficiary against the possibility of insolvency on the part of the trustee. The company, as legal owner of the bank account, was trustee. The customers were beneficiaries in the period between making a prepayment and receiving their items. Again, an express trust is uncovered from the parties' actions without needing any conscious intention to create an express trust. As for the requisite certainty of words, it is well settled that a trust can be created without using the words trust or confidence or the like. The question is whether in substance, a sufficient intention to create a trust has been manifested. Okay, and that's what McGarry was saying in this case. Note that where the circumstances are such that it would be unconscionable for the legal owner to deny the beneficial interest of the beneficiary, the court is likely to infer a constructive trust rather than declare that there was an express trust created. So don't get confused between an inferred express trust and a constructive trust. They are both distinct and separate, but this distinction isn't always clear. So a constructive trust will be found where it would be unconscionable for the legal owner to deny a beneficial interest to a beneficiary, whereas an inferred express trust will be created where the court finds it was the intention of the settlor to create an express trust. Now the other case is James and Locke, and this case shows that the finding of an intention to create a trust is based on the surrounding circumstances. So in this case, a father returned from a business trip to Birmingham and he was scolded by his wife for not bringing back a present for his infant son. In what appears to be a sort of a bit of a temper, he went upstairs, wrote a cheque out in favour of himself as payee, came back downstairs and shouted, "Look you here, I gave this to the baby," and thrust the cheque into the baby's hand. Now the issue arose whether there was a trust created over the cheque or the money represented by the cheque for the benefit of the baby. It was found that there had not been a perfect gift of the cheque because it was made out in the father's name without having been endorsed in favour of the baby. The court held further that there was nothing to indicate an intention to create a trust of the cheque. Rather, the father's intention was either to make a gift or simply to make a point to his wife, in which case he intended nothing at all. Lord Cranworth found that the arguments for a trust was merely an attempt to circumvent the failure to make an effective gift by advancing an argument for a trust. Therefore, he held that this imperfect gift could not be made effective by other means, and that there had been no intention to create a trust here. Okay, and the final case we're going to look at with regards to inferred intention is Don King Productions and Warren. And this case involved two famous boxing promoters. Don King was the leading boxing promoter in the USA, and Frank Warren was the leading boxing promoter and manager in Europe. The two men formed a partnership agreement whereby they and the companies which they controlled agreed to exploit agreements with boxers in Europe for their mutual advantage. Under the partnership agreement, each partner was entitled to hold the benefit of any existing or future management agreement for the benefit of the partnership. Subsequently, one or more of the partners attempted to terminate the partnership agreement and sought to argue that certain management agreements did not fall to be included in the partnership property. The question arose whether the partners held the benefit of the management agreement on trust for the partnership. The partnership agreements were found on their true construction to show an intention that the management contracts were held on trust for the benefit of the partnership. Okay, I think that is enough cases on inferred intention, but just to finish up this video and these 3 videos on certainty of intention, we're going to quickly look at shams and fraud. So in some circumstances, an express declaration of trust may not form a trust if the transaction is a sham or fraud. So when a purported trust is in fact a sham intended to achieve some sort of ulterior purpose, then the trust will not be valid. And a sham is a scheme of action which seeks to create the impression that the state of affairs is X, where it is in fact Y. Okay? So sham trusts are used to avoid liability to tax by pretending that property is held on trust, or frequently so as to attempt to put property behind the reach of creditors in insolvency. And now there are a number of cases on resulting trusts in which the absolute owner of property have sought to disguise their ownership of that property, perhaps to avoid creditors, by purportedly transferring it to other people with the intention of recovering the property in the future, perhaps when the creditors have given up their chase. Frequently, these have been unlawful attempts to put property beyond the reach of creditors, often by putting that property into the names of family members. So in the following case, a trust was attempted to be created so as to shield their property from their creditors, contrary to insolvency law. So in Midlands Bank and Wyatt, Mr. Wyatt sought to protect himself against the possibility of business failure by settling the family home on trust for the benefit of his wife and his daughter. In time, Mr. Wyatt's business went into insolvency, owing money to the claimant bank. Mr. Wyatt sought to rely on the purported declaration of trust, and the problem was, however, it transpired that neither his wife nor his daughter had been told of the trust. Significantly, when Mr. Wyatt had separated from his wife's solicitor had not been informed of the existence of the trust when calculating the wife's beneficial interest in the property held under the divorce settlement. Therefore, the court held that the trust had been a sham, the sole purpose of which had been an attempt to put property beyond the reach of Mr. Wyatt's creditors and not to organise the equitable interest in the family home. So that's an example where there was sham or a fraud. And finally, consequences. Where a trust fails for lack of certainty of intention, there is no trust and the legal owner takes the property absolutely. Thus in Lamb and Eames, where the widow had left the property outside the family against the wishes of her late husband, there was no trust, and the widow, who was the legal owner under the will, also held the beneficial title. Accordingly, the property was hers to dispose of as she wished. So, for example, if a trust is created by the legal owner but it fails due to lack of certainty of intention, then the legal owner will also be deemed to hold the beneficial title. Excellent. That is the end of certainty of intention, and in the next video we're going to be looking at certainty of subject matter. If you have any questions about this video, please leave a comment below and I'll get straight back to you. Don't forget to like this video and subscribe to my channel. Thank you very much for watching.